Today we're talking about bail. A person can be released on bail in two situations. Number one, when he is charged or involved in an investigation for a bailable or non-bailable offence. For a bailable offence, the person is entitled to bail as of right. For a non-bailable offence, the person can only be released on bail if the court decides to do so. The main purpose of bail is to ensure that the suspect or the accused person involved in the court proceedings attends court or attends before the investigators as is required. This would also mean that the main responsibility of the bailer or accused person is to ensure that the suspect or accused person does attend court whenever he is required to do so. One of the main conditions of bail is that the suspect or the accused person being granted bail is not allowed to leave Singapore without either the permission of the court or the permission of the investigator. If he does this without getting permission first, a warrant of arrest may be issued against him and he will be arrested by the authorities. And if this happens, the bail may be revoked and the bailer will then have to attend court to give reasons why the bail amount and monies should not be forfeited. Many people ask, what does it take to be a bailer? What is the criteria for being a bailer? A bailer has to be at least 21 years old and he must not have any ongoing or outstanding criminal matters against him. A person is also not allowed to be a bailer if he is an undischarged bankrupt. And he must be able to provide the amount of bail monies that is required. Although strictly speaking, a bailer doesn't have to be a Singaporean or permanent resident, this is a very common condition placed on the bailer by the court. Bail monies can be provided in two forms. One, if the bail amount is up to 15,000 Singapore dollars, the bailer is able to give a declaration to the court or to the investigators to say that he has assets of up to this amount in terms of either jewelry or other valuable items. Number two, if the bail amount exceeds 15,000, then the bail monies has to be provided in cash. And this can be then given in a few other forms. For example, in the form of a cashier's order or by showing to the bail center or the authorities that this amount exists in a personal bank account. The purpose of showing that the amount exists in the personal savings account is so that the authorities can then freeze this amount for the purpose of bail and only release it after the bail bond has been discharged. So there you have it, some simple information about bail. Thanks for watching. See you again soon. Bye-bye.